Legislation and Legal Issues in Digital Business, presented by Tessa Sewell, Beatrice Evans, Ziad Haji, Cameron Pringle and Kyle Murray. New and emerging technology leads to new possibilities for business models. Technology, and hence its application in business, is evolving rapidly. It is inevitable that some elements of society will always seek to exploit others and subvert existing law. Regulations and law take time to develop and get approval by governments.
From June 2014, the Consumer Contracts Regulations came into effect, which implements the Consumer Rights Directive in UK law. These regulations are for items purchased online or at a distance away from the trader's premises. The Consumer Contracts Regulations has replaced the distance selling regulations and doorstep selling regulations and have clear regulations on the trader's obligation to supply certain information to the consumers. The trader is no longer allowed to have pre-ticked boxes where an item is selected for the user without them actively choosing to do so. If the consumer is charged for something in this way, they are entitled to their money back. For example, if you were to take out an extended warranty on an item and you had not specifically chosen to do so actively, this is something to consider if your business is a subscription-based business, such as a Graysbox style service. This would mean that you could not pre-select any options for the user, such as regularity of their deliveries. The consumer now has the right to cancel thanks to the Consumer Contracts Regulations. This means the consumer is able to cancel at any time in their contract within 14 days. 14 days is the minimum cancellation period, and the trader must offer. Some may offer a longer period. This should always be stated in the terms and conditions of the contract. There are some services in which the consumer doesn't have the right to cancel, and this includes booking hotels, flights, car hire, concerts and other ticketed events where the trader is carrying out urgent repairs or maintenance. There are specific provisions regarding cancellations when it comes to digital content. If the consumer is to cancel their contract, the retailer or trader should not supply any digital content within the 14-day cancellation period, unless the customer has expressed their consent in doing so. The trader must ensure that as soon as the consumer starts the download, they are aware that they will lose their right to cancel, meaning that the consumer must make sure that they want the content before they download it. The regulations state the consumer then has a further 14 days to return any goods that they have received. After the goods are returned, the trader should offer a refund. The refund can be a reduced amount if the value of the goods has decreased as a result of the consumer handling them. Some circumstances where the regulations won't give you the right to cancel include CDs or DVDs or software, if you've broken the wrapping, and tailor-made or personalised items and perishable items. The Consumer Rights Act states that the retailer is responsible for the condition of any goods until the goods are received by the consumer, meaning that they are liable for any transport. This would mean for a subscription service that the products must all arrive intact and in date. The consumer is eligible for a full refund should the delivery be later than agreed, if the delivery time is essential. The consumer is eligible to a full refund should the items be faulty or not as advertised. This includes delivery charges. Should your company have a helpline for customers to contact you on, they must ensure that they are not charged in excess for using this service. This is part of the Consumer Contract Regulations. This may come into play when customers are calling to make a complaint or to inquire about their order, meaning that the trader cannot use premium rate numbers. This charge can be claimed back by the consumer should the trader not comply.
Consumer protection from unfair trading regulations. From special offers that don't exist to closing down sales that run for months and months, some companies use underhand tactics to get a sale. The Consumer Protection from Unfair Trading regulations provide consumer protection from unfair or misleading trading practices, misleading omissions and aggressive sale tactics. Misleading actions. Businesses are not allowed to use misleading or underhand tactics to get you to part with your money. This includes advertising products that may not exist. For example, showing pictures of new clothing items on a clothing website that aren't for sale on the website, let alone even being that brand of clothing. Companies are also banned from lying about goods or passing them off as another product or brand to give them a higher credibility. This could be adding real leather onto a pleather jacket to make it more expensive and a more desirable item. Misleading omissions. In many cases, what's being said is not the problem at all, it's what's not being said that's the cause of many issues. If a trader does any of the following, they are misleading the consumer. Omits material information that the average consumer needs according to the context to make an informed transactional decision. Hides or provides material information in an unclear, unintelligible, ambiguous or untimely manner. fails to identify the commercial intent of the commercial practice if not already apparent from the context. An example of this would be failing to mention on a second-hand clothes site that the item has a fault, such as a small tear which would affect the buyer's decision-making process. Sales tactics. Sometimes having sales tactics can influence the buyer greatly. However, if traders are too pushy and fail to take no for an answer, refuse to leave until a contract is signed, for an example, or use threatening behaviour, these are all classed as committing an offence. Harassment, intimidation, including physical force, used to sway a consumer are just some of the criteria that this legislation contains. Banned practices. Within the consumer protection from unfair trading regulations, in addition to collaring misleading and aggressive behaviour, it outlaws 31 specific practices that demonstrate wrongdoing without the need to demonstrate the behaviour. The following are just a few from the 31 practices. Bait advertising. This is enticing the consumer with eye-catching advertising around distinctive prices when the trader knows they cannot offer the product or there is a very limited number in stock. Bait and switch. This is the promoting of a specific product with the intention of giving you something completely different. False free offers. This is labelling a product as free or without a charge. If the consumer has to pay anything other than the inevitable cost of responding to the offer and collecting or paying for the delivery of an item. As of the 1st of October last year, new amendments were added to the Consumer Protection from Unfair Trading regulations, which give you the new rights to redress. This breaks down into 3 key areas. Number 1, a right to undo the contract. This is being able to end the contract or get a refund within the condition that you haven't fully consumed the goods or digital products or received a service in full. Number 2, a right to a discount on the price paid. This entitles you to a 25%, 50%, 75% or 100% discount on the payments. This depends on the severity of the trader's behaviour and actions. Number 3, an entitlement to seek damages. If you sustain financial loss that you wouldn't have done if it weren't for the trader's actions, you can claim for the damage. This also applies if you have suffered distress or a physical inconvenience because of the trader's actions. For example, if a beauty product has caused a severe reaction because of faulty testing of the product, you will be able to contact the trader and claim against them.
Data Protection Act 1998. The Data Protection Act 1998 came into force in March 2001. The act was designed to protect the privacy and the protection of all personal data collected for or about citizens of the EU, especially as it relates to processing, using, or exchanging such data. The 8 Principles of Data Protection Act 1998. The data must be fairly and lawfully processed for specified purposes, adequate, relevant, and not excessive, accurate and up to date, not kept for longer than is necessary, processed in line with individual rights, secure and not transferred outside the European Economic Area without adequate protection. In order to understand the impact of the Data Protection Act and how it is implemented in digital business, let's take a look at online printers company and how they comply with this act. This company has a designated data protection officer who deals with customers' data deletion and correction. Practically, when customers log in to place an order, a clear message will pop up to indicate how keeping personal data safe and secure is crucial. Also, company allows customers to access the data privacy statement via the hyperlink below. Risks of non-compliance. The Information Commissioner's Office has the power to fine organizations up to £500,000 for breaching this act. These organizations shown below were fined for breaching the Data Protection Act. To find more about the story of these fines, go to the link below.
Intellectual property law. Intellectual property is something unique that you physically create. An idea alone is not intellectual property. For example, an idea for a book doesn't count, but the words you've written do. While intellectual property law has evolved over centuries, it was not until the 19th century that the term intellectual property began to be used, and not until the late 20th century that it became commonplace in the majority of the world. The three main types of intellectual property rights are patents and designs, trademarks, and copyright. Patents and designs. A patent is an intellectual property right granted to an inventor by a country's government as a territorial right, usually for 20 years. In the UK, obtaining a patent involves making a formal application to the Intellectual Property Office. Having a patent makes it illegal for anyone except the owner or someone with the owner's permission to make, use, import, or sell the invention in the country where the patent was granted. Patents protect the features and processes that make things work, allowing inventors to profit from their inventions. It protects new inventions and covers how things work, what they do, how they do it, what they're made of, and how they are made. It gives the owner the right to prevent others from making, using, importing, or selling the invention without permission. Trademarks. Trademarks are symbols that differentiate goods and services in the marketplace, like brand names and logos. They can be used as marketing tools so that customers can recognize particular products or services. The trademark can be, for example, words, logos, or a combination of both, and distinguishes particular goods and services from those of competitors. A trademark must be distinctive in terms of the goods and services provided, i.e., it must be recognizable as a sign that distinguishes one organization's goods or services from someone else's. A registered trademark must be renewed every 10 years to keep it in force. Copyright. Copyright is a legal right created by the law of a country that grants the creator of an original work an exclusive right for its use and distribution. The exclusive rights are not absolute but limited by limitations and exceptions to copyright law, including fair use. In most countries, copyright lasts a minimum of life plus 50 years for most types of written, dramatic, and artistic works, and at least 25 years for photographs. It can be different for other types of work. The examples shown appear in the footer of websites which these organisations have created. Any redistribution or reproduction of part or all the contents in any form is prohibited other than the following: printing or downloading to a local hard disk for personal and non-commercial use, copying the content to individual third parties for their personal use, but only if you acknowledge the website as a source of material.
The new Consumer Rights Act recently came into law on the 1st of October 2015, with the intent of making consumer law clearer and easier to understand. With UK consumers spending approximately £90 billion a month, it is beneficial for both businesses and the public to have access to rights which are transparent, in order to help them make better choices when they buy and to save them money. The new Act replaces a number of laws with regards to business-to-consumer or B2C transactions, most of which are outlined in both the Sale of Goods Act of 1979 and the Supply of Goods and Services Act of 1982. The new legislation is now clearer and easier to understand for both the consumer and the business. This adds confidence to both parties in purchasing and selling goods as the rules are more specific. The new rules are presented simply as bullet points and summaries of the applicable rights of the consumer, which also strengthens the business understanding of the new laws. For the first time, legislation is now focused on the rights to the consumer in terms of purchasing and downloading digital content. Previously, anyone purchasing digital content had 14 days to change their mind. However, this right was waived if the download had begun. This is now no longer the case, with an entitlement to a repair or replacement if the goods are faulty. If a fault has damaged the purchaser's device and the seller has not used reasonable care or skill, you may be entitled to a repair or even compensation. For example, if you purchased software from an online retailer and you found the goods to be faulty, even after the download was complete, the retailer would be required by law to replace the software. Consumers can now ask for a service to be repeated if it is not carried out with reasonable care and skill, and even request money back if a service cannot be repaired. Also, if a price or time has not been agreed up front, what you are asked to pay must be reasonable and the service must be carried out within a reasonable time. Any contract entered into and provided by either party in a B2C environment from the 1st of October 2015 must now adhere to certain parameters set out in the Consumer Rights Act of 2015. Contracts must be entered in good faith and be written in transparent, plain, and intelligible form. The Act also provides more flexible powers for public enforcers such as trading standards, allowing such organisations to respond to breaches of consumer law, such as seeking redress for customers who have suffered harm. In effect, companies and online businesses can no longer attempt to confuse customers by providing unfair contracts that are written in such a way as to be unreasonable by the consumer. The new Act also provides new law pertaining to alternative dispute resolution. Utilised in the event of a dispute which cannot be settled between the business and the consumer directly, ADR allows an ombudsman service to step in to help resolve issues. Where this service had been available only in certain sectors, it is now universally available for businesses and consumers to use. However, even though businesses must make the consumer aware of which ombudsman service is relevant to them, they are not required to use ADR unless it operates in a sector where existing legislation makes it mandatory. This is useful for both businesses and consumers as it allows disputes that may be getting out of hand to be mediated by the appropriate ombudsman service. It may be seen, however, to not go further enough in protecting the rights of the consumer, as certain businesses are not required by law to use ADR.